number 95, the people of the state of New York versus James Carr. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, my name is Evan Lumley. I'm here representing appellant. I would like to request 2 minutes for rebuttal.
2 minutes. Counsel, before you get started, I have a question for you. Did either court below have access to the entire grand jury transcript?
I believe that they did, Your Honor. I did not have access to
They
that.
did?
I
Both
believe
the
that they
Nisi
did.
Prize Court and the Appellate
I
Division?
believe that requests were made by both, yes, Judge.
Thank you.
As you know, 19075 requires that a prosecutor obtain leave before representing a case to a second grand jury when those charges have already been presented. The court, when it decided Wilkins, stated that when charges are withdrawn from a grand jury consideration, that is the equivalent of a dismissal, depending upon how the
Counsel,
extent.
basic question on this grand jury. Are they investigating, and this is really a basic question, are they investigating this crime, right? It's a burglary, it's a murder, they're looking at who can we charge, or are they just investigating this defendant?
I believe, based on what I've seen from the record, that they are investigating this defendant. And I think that that's clear based upon the waiver of immunity that they execute with him.
But you have a crime which involves a murder, you have potentially a number of suspects. Would you have to get separate grand juries for each of those suspects?
I guess it depends on when they're being presented. If they were being presented.
So right now you go in and you don't have evidence that this person committed, let's say a different case, robbery, and a couple of guys rob a number of people, they kill a few, you open a grand jury investigation, robbery and murder, you have evidence of one shooter at the time you're going into this grand jury, you charge that shooter with murder and robbery, you charge 2 other people with just the robbery. Turns out one of the victims who was shot recovers and can testify and says, in fact, they handed the gun over to this other defendant during the robbery, and he shot victim 2 or victim 3. Can't you go back in now and get a murder indictment, or do you have to get permission?
Your Honor, we're talking about specifically for different defendants than
Yeah, so you've charged one of the defendants with being the shooter. Now you learn the gun was passed. Another defendant was the shooter of one of the victims. You now have enough to charge another defendant with a murder. You go back in and you get a murder indictment. Why can't you do that without permission?
Well, in that scenario, it would be with respect to a different defendant and a different proceeding.
No, but let's say that defendant was charged with robbery as the result of the first grand jury, but he just wasn't charged with murder.
Judge, if that particular defendant was not under investigation at that time, then I believe that the second.
But how could he not be if he was charged with robbery?
Well, Judge, I think that goes to the core of my argument here, is exactly that.
Right. I think it does, because here they got a burglary charge, right? And they didn't have the murder, but later I guess they develop a jailhouse informant or something, and they come back in and they charge him with the murder. Why is that different?
Well, especially in this proceeding, this defendant was present for the grand jury, and he testified, and he was not afforded that opportunity to come back and testify.
Well, putting that issue aside, just on the issue of did they withdraw this so it's the equivalent of a dismissal, why isn't that so different than our earlier case saying you can go right to the end, put all your evidence in and say, well, wait a second, we're not going to present a charge here. I mean, here they had evidence he committed the burglary. They charged him with that. They asked for an indictment. The grand jury returned an indictment on that.
I think that they were attempting to charge him with the murder. In my opinion, that's specifically laid out. And for whatever reason, I can't be in the mind of the prosecutor.
And what leads you to think that?
The questioning, the line of questioning that the defendant was subjected to.
About the immunity waiver, or what?
Oh,
what
there's
line?
specific portions in the record where he testifies that they specifically say, isn't it true that you said that you killed Percy Blake Saunders? And he answers no. It's peppered throughout the testimony that there's certainly a strong inference that he's being investigated for this murder, and it gives the appearance to be, when I'm reviewing that
So
testimony.
you thought
And
that
based on
the,
what you've just described as the evidence, would the prosecutor have been faithful to his or her ethical obligations if he or she had asked a grand jury to indict on a murder on what you're describing as the evidence before that grand jury?
That's certainly a determination for the prosecutor to make, and perhaps not, but that's what the evidence was showing.
That mean because there's not a legally sufficient case at that point in time?
Of course, perhaps. And with regard to that point, it was certainly something that was drawn to the attention of the grand jury. And I don't see why he shouldn't be required to obtain leave if he is acting ethically, just to represent that to a second grand jury.
What do you make of the language in 190.75 that says, "or any other offense"? That is, to put it differently, in Wilkins, the grand jury returned nothing. Here, the grand jury returned a burglary charge, and the statute says if the evidence isn't legally sufficient to establish that the person committed such crime or any other offense, then you have to go back to court. But here, the grand jury returned a charge.
Well, what I'm asking the court to consider is that the equivalent of what happened in Wilkins, where the prosecutor withdrew those charges. The court did not state that they had to be specifically charged on those offenses for that to be considered a withdrawal. This grand jury heard testimony from 17 witnesses over 17 days. They presented everything, and I don't
But
know.
was any of that testimony unrelated to the burglary?
I don't know that answer because I haven't had the opportunity to review the grand jury minutes. What I have seen.
If it was all related to the burglary, would that make a difference? Even if some of that may have led to an inference that he might have been also involved in the murder?
I think that it seems foolish to say that this defendant was not being considered for that murder charge. Well, he is a suspect of a burglary.
Well, but isn't there a difference between, okay, we're thinking about this and, but we don't have enough proof yet, and so we're not looking to indict him on this now. But because of the interrelation between the burglary and the murder, there may be some things that come out that have to do with a possible connection to the murder. But I mean, in what you've presented, I don't see a whole lot of proof that would suggest that he's guilty of murder. So it doesn't seem to me that charge was actually presented to the grand jury.
I understand your point, and
Following up a little bit on Judge Stein's point, let's assume, for the sake of the argument, that he was a suspect, and they very clearly knew he was a suspect in the murder. Are you suggesting that in order to protect the murder case, even though they had solid evidence of the burglary, that they shouldn't go in and present the burglary? Is that what you are saying in order?
no, I believe that from looking at the circumstances in this particular case, that this defendant was subject to an investigation for murder. I believe that that's very clear based on the questioning.
Okay.
I believe that he was held on a criminal complaint that was charging him with murder at that time.
No, actually, I think the complaint charged the burglary in the first degree.
Your Honor, again, there's nothing that would impede the prosecutor from going and obtaining leave and presenting whatever it is that he believes that now.
But let's say, following up on the Chief Judge's question, the prosecutor doesn't want to lay his case out for a judge at this point, but he has very strong evidence that there's been a robbery, there's been a burglary, it's a very serious crime, there's been a murder committed, so of course whoever committed the burglary or robbery would be a suspect in that. But would this rule chill the prosecutor from going in and getting an indictment on a burglary or robbery charge because they don't want to be considered to have a grand jury dismissed a murder charge?
No, certainly not. But what I'm asking the court to consider, and there's certainly a disadvantage here because we haven't had the opportunity to review those minutes.
Would you
Well,
agree?
well,
Would you agree?
let's talk about, this went to trial. You have access to the grand jury testimony of all those witnesses who testified at trial, because that would have been turned over to the defense as either Rosario or, no, typically Rosario.
We did not have that opportunity on this particular appeal. And that was a result of time, unfortunately for us. We didn't learn of the issue where leave was not sought by the prosecutor until the request was made for that years later. The record that we were able to obtain was at the clerk's office. It was very limited in scope and respect. We didn't have an opportunity.
So your record is limited to what was in front of the 440 judges, what you're saying?
That's correct, Your Honor.
Okay.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the court. Nicholas Texedo for the people. The permission requirement in CPL 190.75.3 is not triggered unless there's a dismissal by a grand jury. That's by the clear language of that statute. Now, Wilkins expanded that a little bit, but only where there's a complete withdrawal of a case prior to any grand jury action. And the reason for that was because CPL 190.60, and this is the language of this court, does not contemplate the termination of deliberations without some action by the grand jury. Now here, this is different. This isn't Wilkins. Here we had action by the grand jury.
Did the complaint charge murder?
I'm
Did the
sorry.
complaint in this case charge?
The felony complaint.
As far as I know, it did not. I was looking while you were discussing it with my colleague, but I didn't, I don't believe it did.
So are you saying that if you had gone in and presented all of your proof on the murder charge, and, but didn't instruct the jury, and they returned an indictment of burglary only because it was the only count formally submitted, that the people would still not need leave to represent the murder charge?
Yes, I don't think you have to get there in this case to rule in my favor, but I do think, yes.
That would be
that's-
the impact of what you're suggesting under,
Yes, it would. That particular part of my argument, yes. And the reason for that, and it's right
didn't
from.
that go contrary to the whole policy?
Well, no, because I think the policy reasons in Wilkins were very fact-specific, and they were limited to the unique circumstances of that case. In that
About the
case,
policy reasons of CPL 190.75.
right, and I don't see how the people presenting a murder case after only asking to consider a burglary in any way goes against the policy
No,
in
that's not what
CPL.
I'm suggesting, that if you had put in all of your proof of murder but never charged the grand jury with the murder, only charged them with the burglary, that's my question.
Yes, I still think even under 190.75.3, the plain language, and under Wilkins, that the people will be allowed to do that without permission.
So is the
And-
policy behind the statute to prevent grand jury shopping?
Yes, it is, I believe. And when, there's a lot less of a risk of that when the prosecutor actually asks the grand jury to vote on a charge. And here, parenthetically, the grand jury unanimously voted to indict on the burglary count. There was no indication that the first grand jury was in any way looking at the people's case and with any form of skepticism. And in Wilkins, the record was replete with that. And this court said, under these unique circumstances, it was tantamount to a dismissal. The court also said in Wilkins, and this is a quote, where a particular charge has not been presented to a grand jury considering another charge, the first charge could not be considered dismissed. So even under Wilkins' own plain language, where, in your hypothetical, Your Honor, where the court was not presented with the law surrounding the murder charge and asked to consider that, the people would later be able to go in and present that.
But that's not forum shopping because what? You're presenting the evidence, it's not going the way you want, so you don't submit the charge.
Well, in the hypothetical, the people have submitted a charge, and it's the burglary charge.
You submit a different charge.
Right, I think,
That's what I'm saying.
right, I think
You-
it's a lot less
You're
of a,
presenting the evidence.
Right.
But something, the prosecutor determines this may not go as I had hoped, and then doesn't submit the charge. Why isn't that grand jury shopping?
well, it's a lot less of a risk of grand jury shopping when you're not talking about the complete withdrawal of a case, because it would take quite a bit of, I guess, planning and quite a bit of manipulation for a prosecutor to say, okay, well, I'm going to present this charge because I think they might indict on this one, but they're not going to indict on this other charge. If the grand jury is a non-compliant grand jury or whatever the language was from Wilkins, I don't think they're going to indict on any charge. And so I think there's a lot lower of a risk of grand jury shopping. And the other reason in Wilkins, the whole
The
reason,
defendant testifies and seems quite believable and persuasive. Says, yeah, I maybe says something that inculpates him, in this case him, on one charge, but not on the murder.
Right,
There's nothing
well-
else to connect them.
requiring permission in that situation doesn't in any way protect the defendant's right to testify again in a future grand jury proceeding. It's a policy that's not, it doesn't fit the harm that the court will be looking to prevent. Because the people could go gather some more additional evidence, make an ex parte application, and that's what 19075 applications
Let
are.
me give you this hypothetical. Suppose you have an incident that occurs, and it involves an incident of domestic violence, but there are other charges that are also uncovered in the course of the processing of this arrest, such as he has drugs on him, making the defendant a male, and let's assume the victim is female for this hypothetical. And, you know, they're serious enough injuries that it's felony level, so it's being presented to the grand jury. And you know what? They never, the victim never tells you that she's going to end up recanting in front of the grand jury, and then recants in front of the grand jury and says, yeah, no, he didn't hit me, he didn't swing a knife at me, or whatever, you know, it may be. Now, you have enough evidence in front because you put your police officer who recovered the drugs and you vote out the drug charge. And you choose not to present the DV charges at that point to the grand jury because now you have a witness who went and flipped on you. What happens then?
I think in that case, under Wilkins and under the other cases, which hopefully I'll get to, that would not be considered a dismissal of those counts. Wilkins was very limited, and it was when the grand jury doesn't dispose of a case in a manner consistent with CPL 19060, then it can be considered a dismissal. But in the case, in the hypothetical that I'm being presented with, the grand jury is disposing of the case in a manner consistent with CPL 19060 by voting to indict on the only count they're being asked to
So in
indict
other
on.
words, it comes back to as long as they vote out one charge, that's enough, and
I think that's
that's
true.
the
and
ironclad rule. Doesn't matter how much evidence you were intending to put in, or you could have put in, or you did put in.
I think that's correct, Your Honor, and I think this court in Cantwell held as much. And I want to talk about Cantwell for a second. In that case, the trial court, the grand jury no-billed the charges. And the trial court ordered the people to submit the lesser included offenses. And that's under 19075-3-2, and it's the same standard for whether the trial court can order it or whether the people need to seek permission. And what this court said is, because the grand jury disposed of the case in a manner authorized by CPL 19060, that 19075-3 only applies to counts that were actually considered by the grand jury, so not the lesser included offenses. So in that case, clearly the grand jury heard evidence of the lesser included offenses because they heard evidence of the greater offenses. But this court held that 19075-3 doesn't apply because the grand jury wasn't actually instructed on the law surrounding those counts and didn't actually consider it.
But in that situation, there would be no reason to think that the DA was holding something back or not, not presenting a charge because he or she didn't think that grand jury was going to indict. Because it was subsumed completely within the greater charges. So as far as the policy is concerned, that case is just, seems to me to be completely distinguishable.
Well, I would, if we're talking policy, I'd like to talk quickly about superseding indictments. Because it's clear that if the grand jury considers a certain charge, the people can go in before plea or trial and supersede that indictment. And there's no requirement that they get permission. This court has held that explicitly. Now,
You have to go to a different grand jury?
you can, this
I mean,
court in
if this
Cade
grand
said,
jury is expired, you can go to a different.
right, in Cade, this court said, if the grand jury has voted favorably on the charges, the district attorney is at liberty to resubmit to the same grand jury or, quote, to an entirely brand new grand jury without court approval.
But in
And
that case, as I recall, grand jury practice in federal, you have to resubmit everything you put in the first grand jury.
If it's a new grand jury, yes, the
Right.
people do.
So that's a little bit different.
Right, and I think that's also a reason why, when you have the grand jury vote on one count, that it's less of a concern of forum shopping by the prosecutor, because prosecutors don't want to present full cases to multiple grand juries. I think that prevents the harm in and of itself.
Mr. Texedo, when I inquired of your colleague as to whether or not he knew if the courts below had the grand jury, full grand jury transcript, he said he believed so. Do you know for certain?
I know for certain that the appellate division did, and I believe also that the trial court did
Thank
as
you.
well. And just briefly, I see my time is up, but I would say even if the court does not rule in my favor on the arguments, the legal arguments I was making, looking at the facts and circumstances of this case, the grand jury was not presented sufficient evidence of a murder. There was no ME or a medical examiner, no cause of death, nothing to link this defendant to a murder. So it can't be said that the grand jury considered under Wilkins the robbery or murder counts. Thank you, Your Honor.
Thank you, counsel. Counsel?
Thank you, Your Honor.
Welcome.
What I'd just like to point out is that it's clear throughout all of the case law that is directed towards this issue, that it depends on the facts and circumstances of the underlying case. It's a very strong indication that it can go one way or the other. And,
But isn't that point out a problem here, which is Wilkins says this is the equivalent of a dismissal, essentially by getting inside a prosecutor's head. In that case, it's fairly straightforward because no charge is presented. It gets harder to do that as the facts and circumstances change, but that's what the court's really being asked to do. Why wasn't a murder charge presented and a burglary charge? That's a lot harder than you made your whole presentation, you got up to the point where you would submit a proposed indictment and then you say, never mind. And is that really the role of any court to be doing that?
The biggest concern, I believe, that exists in this case is the fact that the defendant did testify on his own. For whatever reason, he was questioned with, as I stated numerous times, he was questioned directly with respect to this murder. That grand jury heard that evidence. The DA, for whatever reason, decided not to ask them to consider that charge. I believe that something happened. Maybe he felt that that defendant was believable, but when he represented that same issue to the second grand jury, the defendant wasn't afforded an opportunity to be present. There was different evidence that was presented in a very limited scope with respect to...
Did he have a right to be present at that second, to notice of present the grand jury proceedings on that second grand jury?
He wasn't held on a criminal complaint at that time. However, I believe that he should have had an inherent right to be present.
But is there any statutory authority for that?
There's lower case law on that. That issue's never specifically been decided as far as I'm aware. But there is a case that suggests that a defendant who has previously testified should be afforded that opportunity again. And I believe that was fundamentally fair for him to be able to do that, especially given the circumstance that this is being represented a second time to another grand jury that's not hearing his testimony. And there's this issue of another witness that comes out of nowhere, and that's the only additional evidence as far as I'm aware.
Thank you, counsel.
Thank you.